Okay, the meeting will come to order. Okay, please call the roll.
Senator Surville. Senator Surville is here. Delegate Bagby.
Present.
Delegate Mullen.
Present.
Delegate Samira. Christy Kelly. James Abrenio.
Present.
Commissioner Land, represented today by Stacy Pendleton.
Here.
Commissioner Oliver, represented today by Senior Policy Analyst Allen.
Here.
Commissioner Storin, represented today by Nikki Callahan.
Here.
Delegate Price.
Here.
Senator Edwards.
Here.
All right, thank you, Mr. Chair.
Okay, thank you very much. We have a draft of barrier crimes legislation. Anna Muir and Sabrina Miller Bryson, attorneys at DLS. Who would like to go and explain what the draft says?
Thank you, Mr. Chair. Yes, thank you. So as Senator Edwards said, we have completed the first draft of potential legislation. And the materials sent out that are also posted on the study website, you can find the agenda, the draft legislation, the accompanying summary, and the same two lists of barrier crimes that we sent out at the last meeting. The first one titled List of Barrier Crimes as set out in 19.2-392.02 lists the crimes in the exact order as they are listed in the code. And the second one lists the barrier crimes by felony and misdemeanor classifications. The presentation that we are about to share will be posted on the study website after this meeting as well. So let me go ahead and share my screen. Okay, can everybody see that?
Good. Yeah, go ahead.
Okay, so as you all will recall in the last meeting, I did a drafting presentation, and that was to give everyone an overview of how things are set out in the code now, some information on why things are set out that way, and some options on how we can rework the barrier crimes provisions. Based on the options, this body directed Sabrina and me to complete a draft for this meeting, establishing a waiver process that each agency will oversee for its applicable groups. This is also consistent with what has seemed to be the most appealing option to members all throughout the study. We have sometimes called it an appeals process, but the concept is still the same, where individuals with barrier crime convictions will not automatically be able to apply for these jobs, but they will have an avenue where they can try to apply for and get jobs despite their barrier crime convictions. So that is what we have here in this first draft. It is a 59-page draft, and so we figured the best way to present this in a digestible way in a virtual meeting is through a PowerPoint. And of course, I know all the members here know this, but just for the public, this is just a first draft. It's not necessarily what the final draft will be. We can certainly tweak and change things or even do an entirely new draft for the next meeting. So moving into it. So to give an overview, these are the main components of the draft. We will go over each of these in more detail during the presentation, but to put it simply, a new subsection H in 19.2-392.02 directs the Department of Behavioral Health and Developmental Services, the Department of Education, the Department of Health, and the Department of Social Services to set out a waiver process whereby individuals may apply for employment despite convictions of barrier crimes. A new subsection I in that same section provides a penalty for a business screening service or qualified entity that discharges or discriminates against an individual concerning a barrier crime conviction that was subject to a waiver. We have eliminated some of the barrier crimes from the list in subsection A in 19.2-392.02. We made amendments in the code so that sections and the respective titles of the agencies reference back to the new provisions in 19.2-392.02 for clarity and consistency. And for foster and adoptive parents, the draft limits crimes that are barriers to compliance with federal law only. So to begin with the waiver process can be found on page 14 of the draft, starting at line 364. It requires the 4 agencies to each develop and implement a waiver process for individuals who are employed by or volunteer with, or who seek to be employed by or volunteer with, the qualified entities that each agency oversees and who have been convicted of a barrier crime. The process by which a barrier crime may be waived shall be made available to the public and set out on each department's website in a visible location that is easily accessible and must include the following information. If applicable, which barrier crimes are eligible to be waived, whether there is a requirement regarding how much time has elapsed since the conviction, if an individual is granted a waiver, procedures for how such information is documented within an individual's record of employment or volunteer service and disseminated to the appropriate persons within the department, and any other factors the department deems necessary for consideration.
Anna, I have a question. Are these all the agencies that have barrier crimes? Department of Behavioral Health and Developmental Services, Department of Education, Department of Health, and Department of Social Services. That's it, right?
Mr. Chair, yes, sir. That's those 4 agencies who they apply.
All right, thanks.
Sure. And so also at the top of page 15, starting at the end of line 374, you will also see that we implemented a provision making it clear that an individual who has been granted a waiver but is convicted of a separate and subsequent barrier crime after receiving their original waiver must notify the department of their new conviction no later than 10 business days after that conviction, and a separate waiver is required for any subsequent conviction of a barrier crime. You will recall that we are working with a lot of different industries here, from early child care and public schools to substance abuse facilities to nursing homes and beyond. So it makes sense to give agencies some flexibility to create their own waiver processes and determine when individuals with barrier crime convictions may work with these different populations. And hopefully by requiring the agencies to publicly post the process, including which crimes are eligible for waiver and when, it will be easy for applicants to navigate the process to the extent possible. So as shown on the last slide, the requirement for each department to set out their own waiver process and any other rules and requirements that apply to all the departments are set out centrally in 19.2-392.02, which is in the same location as the list of barrier crimes. This gives us a good organizational foundation, and then in each of the agency's respective titles, so 22.1, 32.1, 37.2, and 63.2, we reference back to that main rule in 19.2-392.02. These cross-references are important for clarity to show to whom the waiver processes and barrier crimes laws apply. The example I have on the slide here that shows how this works all throughout the draft is in 32.1-126.01, which is on page 26, and that's one of our health laws. The law still stands in Title 32.1 that a licensed nursing home shall not hire for compensated employment persons who have been convicted of any offense set forth in Clause 1 of the definition of barrier crime. But we add a new language after this that states, however, the department shall establish a waiver process pursuant to the new subsection H, whereby persons may apply for employment despite convictions of offenses set forth in the definition of barrier crime. So there's that cross-reference, and this same kind of language is done in all of the other existing code sections in each of the agency's respective titles. The idea is that applicants with certain convictions cannot automatically get hired, and that's why we left the restrictions in place as they are currently written, but they would now have the opportunity to apply for it and receive a waiver for the process established by the applicable department. In the draft, we have also eliminated all of the current exceptions, as the new waiver process that each agency sets out will establish which crimes are eligible for waiver and when. The draft limits crimes that are barriers for foster and adoptive parents to compliance with the federal law only. So to give just a quick refresher on where we were coming from with this, there is a child welfare federal law with which the Department of Social Services must comply for placing a child in a foster, adoptive, or relative guardianship home. And this law includes a list of crimes that are barriers for approval to be one of these homes. Under current law in Virginia, in addition to meeting this minimum federal law, Virginia is much more restrictive with regard to barrier crimes for foster and adoptive parents. Based on the information we've heard in multiple presentations, specifically that it would lead to better home placements and outcomes for children if the rules were not so strict, and listening to member discussion in our meetings, the members here have indicated that they would like to limit barrier crimes to just those set out in the federal law for foster and adoptive parents. So that's what we have done in this draft. You can find that change on page 47. And as you can see in the new language, and I put it in the third bullet point as well, the bill eliminates the state level barrier crimes requirements for foster and adoptive parents and provides that a child placing agency shall not approve a foster or adoptive home if any individual has been convicted of crimes prohibited under federal law, or if they're the subject of a founded complaint of abuse or neglect in both state and federal registries.
Okay, so in subsection I of 19.2.392.02, we have created a penalty provision based on the conversations that we've had during the previous meetings. This can be found on page 15 of the draft, starting at line 378. This includes the penalty provision for any business screening service or qualified entity that uses the criminal history record information for any discriminatory reason. We use similar language to the penalty for violating expungement provisions found in 19.2.392.16. And that came from Senator Suravel's bill from the 2021 first special session, SB 1339. This section creates a penalty for a business screening service or qualified entity that discharges or discriminates against an individual for any reason concerning solely the barrier crime conviction that was subject to the waiver. The penalty for violating this section is $1,000 or actual damages, whichever is greater, plus costs and reasonable attorney's fees. The business screening service or entity has the option to make a cure offer within 10 days of filing the suit. The offer must be in writing and must include an offer for something of value, including the payment of money. The offer must be reasonably calculated to remedy a loss claimed by the individual, as well as attorney's fees and expenses. This section will apply when an individual has been granted a waiver. And then Anna, you can go to the next slide. If there are no questions.
Mr. Chairman, I have questions, but I don't know if you want to wait till the end.
Go ahead, Senator Sherrill, go ahead. Let's do it now.
Okay. Yeah. So, Sabrina, I was trying to understand how this got drafted. So, one question I had was why we didn't just refer back to what's already on the books and just say, violating this is a violation of that. Go over to, section 19, whatever it is, 19.2. Yeah, 19.2, 392.16 for the remedy and all that, instead of drafting a whole new remedy in this one place, number one. Number two, on lines 378 to 80, I don't think it correctly captures the standard we're looking for. First of all, under the existing statute, the automatic expungement / sealing statute, the penalty is for dissemination of inaccurate information, not discrimination. I understand that with regard to the qualified entities, we don't want them discriminating against people who've gotten a waiver. That I agree with that. But the business screening services don't discriminate; they disseminate. We don't want them publishing an inaccurate report that does not contain the fact that somebody has obtained the waiver. So it's a matter of dissemination, not discrimination with regard to the business screening service. And so I think we need to sort of clarify exactly what we're asking them to do or not to do. And again, I think lines 381 through 96, I'm not sure whether or not we need all that or whether we can just say go back to the other code section we've already adopted for looking for the remedy. And then the third thing I had was I had a little bit of concern about, and I've been trying to think through how this will work. I'm not clear what effective dates we're talking about on this bill, but this business screening stuff that we passed in the 2020 session does not go into effect until July 1 of 2025 or an earlier date if the Virginia State Police certifies they've been able to get their computers talking to each other before then. And so we're tying to definitions which might not be effective when this law becomes effective, depending on what the plans are. I didn't look to the end of this to see when this all goes into effect. Okay, July 1 of 2024. So I guess we're a year apart there. This proposed draft would become effective July 1, 2024, whereas the business screening stuff that we're referring to doesn't become effective until July 1 of 2025. And so I was trying to understand how all that squared up. So those were my questions about this piece of it when I read it.
Okay. Anna, you want to explain all that?
Mr. Chair, I can take that for Anna. This is Sabrina from Legislative Services.
Right.
I will definitely we can look at the standard. I think that might have been maybe just a typo, and so I apologize for that, and I will go over that for sure. As far as the referencing, Mr. Chair, Senator Serval, back to 19.2, 392.16, I guess figuring out the delayed effective date for this bill would sort of address that issue, whether or not we need to have all of this written in this code section prior to those sections going into effect in 2025 or whichever comes first. So I think that would probably take care of the issue. Anna, let me know if you disagree, or Senator Serval, Mr. Chair, whoever, if anybody disagrees. But I believe that would probably take care of, if we left this language in the draft as is, and then added the definition of business screening service as it's currently written in 19.2, 392.16. I think that would hopefully address the issue if I'm understanding.
Well, I think it's two things. One is,
Mr. Serval.
I'm sorry. Thank you, Mr. Chairman. Sabrina, I think all it needs to say is in terms of the dissemination of the record in this statute, whatever it is we're looking at, 392.02. And again, Ms. Kelly knows a lot more about this than I do, but I think what this probably needs to say is, a business screening service, once somebody gets a waiver, a business screening service shall not disseminate a criminal history record without disclosing the fact that the person has received a waiver.
Okay.
And failure to do so shall constitute a violation of, or shall be subject to all the remedies contained in 19.2, 392.16. Just point back to that. And I think that's all it needs to say with regard to the dissemination of the record. The one part that I kind of liked was that you said also that in here that a qualified entity shall not discriminate against somebody who obtained a waiver, and that they have liability for that. I think that's a good thing, and that concept is not contained in the bill we passed a year and a half ago. But I think that's sort of a different discussion, perhaps, than the release of the report information. So, but I think it's a good thing to make sure that we don't give people this barrier crime relief, and then people just say, I don't care if they got a waiver, I'm not hiring them anyway. So I think that's a good thing that they have that, but I think that there's some other issues in there about how the civil action works that we ought to talk about, but I like the idea.
Mr. Chair, may I follow up?
Yes, Sabrina, yeah, please.
Thank you, Mr. Chair. Senator Serval. So one of the things, just to point out, in subsection H, just above, we were concerned about whether or not we could have the barrier crime reflected within the criminal history record itself, which is why we made one of the requirements for the waiver process that each department will need to establish procedures for how such information is documented within the employment record. So I think that was probably the only concern about how we would reflect a barrier crime waiver within a criminal history record. And that's definitely something we can look into further to address that concern.
Mr. Chairman.
Yes, Senator Serval.
Thanks. One other thing that wasn't clear to me in this was exactly how these waivers are going to be disseminated. In other words, how a business screening service is going to be able to determine or confirm somebody actually got a waiver. And, I don't know if each of these agencies is going to maintain a database that can be searched, or if they're going to publish a list regularly, or if they're going to respond to a FOIA request what we have, I think, in the bill we passed a a year and a half ago, we created a process where you register with the state police to get stuff. And once you've registered, and then you get access to their database once you sign their contract and agree to all their stuff. So I haven't thought through this, but we just need to make sure the information flows so they actually get access to the fact that a waiver has been granted, so that they have the ability to get it onto a background report. Because, all these screening services, they don't all just get their information from the Virginia State Police or the courthouse. A lot of them just pull it off the internet. And, they're not going to find out somebody got a waiver if they're pulling somebody's, cocaine possession charge off the Supreme Court of Virginia's, site where me and Mr. Brinio go to see what's up with our clients' cases. That's where a lot of them get this info. So anyway, we need to make sure all those dots connect.
Okay. Everybody got it? Any other questions? Okay, should we move on?
I'm sorry, Mr. Chair.
Yeah, it's Delegate Mullen.
Mr. Chair, just a question for council as well, just on these provisions. What was the thought process about including or not including assault and battery?
Anna? Sabrina?
Anna, I'll take this one if you want. Mr. Chair and Delegate Mullen, we are actually going to address that in just a moment, in just a couple of slides. So okay. Is that okay if I hang on?
Sorry,
to that?
I jumped the gun. I apologize.
Okay, let's move on. Next.
Okay. So the next thing that we have here is the barrier crimes that we eliminated that can be found on page 11 of the draft, beginning at line 267. We've removed some and changed a couple to felony only. So at the direction of the joint subcommittee from previous meetings, we've removed the class 2 and 4 misdemeanors, which you can see 18.2-88, 18.2 -57.01, and 18.2-87.1. And then we'd also eliminated 1 class 1 misdemeanor and amended 3 additional crimes to be felony only, eliminating the provisions of those crimes that were class 1 misdemeanors. These crimes were eliminated because they seem to be the least severe on the list, and based on previous discussions of the joint subcommittee, I know the members had wanted to keep in most of the crimes against the person and drug crimes as well. So just briefly going over the crimes that have been changed to felony only. If you look at the document that we provided to you titled Classifications of Barrier Crimes, you can see which ones these are specifically and what's been eliminated, but I will go through those. Changing 18.2-56.1 to felony only would eliminate subsection A, which makes it a class 1 misdemeanor to recklessly handle a firearm, and subsection D, which makes it a class 1 misdemeanor for somebody who hunts after their firearm license has been revoked. 18.2-57.02, we've removed the provisions that make it a class 1 misdemeanor for disarming a law enforcement officer of a chemical, irritant, weapon, or impact weapon only. We kept in all of the felony provisions dealing with firearms and other types of weapons. And then for 18.2-60, we removed the barrier for being convicted of this offense when the individual is 18 years or younger, as that's a class 1 misdemeanor. And we've eliminated the class 1 misdemeanor in subsection B, making an oral threat to enumerated persons within that statute. And then Anna, you can go to the next slide.
Good. Next.
One of the outstanding issues that we have is the elimination of additional crimes. If the joint subcommittee wishes to further reduce the number of statutory barrier crimes, we would be more than happy to make those amendments to the next draft in preparation for the next meeting. We will need input here from the members to choose which crimes to remove, if any. One suggestion, or one option rather, we have is the assault and battery statute. I know that assault and battery specifically has been brought up multiple times in our meetings. During our meeting in June, the DBHDS provided us a chart of the crimes that cause the largest number of barriers to employment, the main one being more than one conviction of 18.257, which is assault and battery. Since assault and battery really can span a broad set of circumstances, one option you all have is to make 18.257 felony only. And the felony convictions would still encompass a third or subsequent offense, an intentional assault against a person due to race, religion, gender, disability, gender identity, sexual orientation, color, or national origin, and then assaults against a judge, magistrate, or law enforcement officer, and some other positions as enumerated in subsection C. The second option would be to exclude only simple assault in subsection A, or simple assault and battery rather, in subsection A, so as to leave as a barrier subsections D and E, which make committing a battery against an employee of a school or a healthcare provider a class 1 misdemeanor. The other consideration here is that we can simply leave the statutory barrier crimes list as is. As we have discussed, or as the members have discussed multiple times, each department is being directed to establish their own processes. Each department has their own needs, so cutting down the list further might not be necessary, and we can leave it up to each department within their waiver process.
So a few other outstanding issues that we'll have to address. So as of now, in the current draft, the delayed effective date, we just have a 2-year delayed effective date that applied to the Department of Health because we specifically discussed that with their office. We can add that same delayed effective date or another delayed effective date for the other agencies. The only other one I've really talked to you about this was the Department of Social Services. And at the time they indicated they didn't think they would want to have a delayed effective date, but that could change, and Nikki might want to speak more to that later. And of course, going to Senator Saravel's point, we might have, depending on how we do this new subsection I, we might also have to push some of those provisions out a couple of years. Also, a financial component for more agency resources. This bill will probably have some sort of fiscal impact on at least some or all of the agencies. We are not changing the overall hiring process, so it shouldn't be a major overhaul of already existing employer practices. But since we are requiring a centralized waiver process with each state agency, if the agencies do not already have people who can develop and oversee this process, which I know is the case for at least one and probably more, they will need to hire folks and maybe have other costs that the agency representatives can also speak to if they would like. Sabrina and I are not finance people, so we're not sure exactly what this fiscal impact would look like yet. But you know, depending on where we end things with this meeting, once we kind of do some updates to this draft, we can certainly talk to some of the finance people in our office and have an answer, hopefully have an answer for you at the next meeting.
And then the final outstanding issue has to do with dissemination of criminal history record information and kind of some of the FOIA concerns that flow from that. So one of the pieces of feedback that we received from the stakeholders depending on how each department structures its waiver process, we need to ensure that everyone who needs to be included in the exemptions for the prohibition of dissemination of criminal history record information in section 19.2-389 is in fact included. Currently 19.2-389 does provide for certain allowances for enumerated organizations within each department or agency. We can always add another provision specific to disseminating criminal history record information in conjunction with the waiver process. Additionally, there might be some FOIA concerns that flow from some of the waiver application documents that accompany the application. I think the main question will be whether we need to carve out an exemption for any potentially sensitive documents that could accompany the waiver application, and whether or not those kinds of concerns would fit within the purview of the bill.
Okay, any questions?
Yes, Mr. Chair, I have a few questions.
Good.
Delegate Price.
Okay.
Yes.
Nice to see you. How you doing?
I'm well. How are you, sir?
Good. Good.
So I wanted to make sure, because I know that some of the folks that are very interested in what we're doing are watching. So some of my questions are just for clarification. Can you remind us, are the stakeholders that we consulted with folks that are interested in hiring? When we say stakeholders, they are interested in the work that we're doing because they want to hire people, correct?
Mr. Chair, Delegate Price, yes. We've mostly at this point been communicating with our 4 agency people who are definitely may not be directly hiring these people, but they oversee the entities that do the hiring, and they definitely have a strong interest in trying to make these laws a little bit more flexible for folks.
Awesome. And can you all tell us what, if any, consideration in the conversations did rates of recidivism come into play? I know that, some of the information that we had talked about way back when we first started this go round, I don't know that I've seen the actual data, but has that been a part of the conversation? Say, for instance, if there are certain crimes that have a very low recidivism rate, then we might be more lenient versus some that have higher recidivism rates. But in that conversation about, protecting the folks that they'll be working with, just wanted to see where that was.
Mr. Chair, Delegate Price, we have not specifically been discussing those things at this point with the agencies. We've just mostly been communicating with them to make sure that this draft looks okay and it's something feasible that they could do at this point. But I know we're, certainly interested in that feedback to the extent that we can get it. I do remember a few meetings ago, some of the agency folks indicated they were unable to get some of the recidivism data just because of the way their process works, working with third-party services. Sabrina, did you have something to add to that? Or?
No, I was just going to say we haven't looked into that yet, but it might be something we could potentially look into prior to the next meeting. No promises, but hopefully.
And Mr. Chair, just 2 more questions. Sorry. Thank you, Mr. Chair, for the conversation, just to make sure when we were going through those lists of crimes and classifications, for our purposes, we are not changing the punishment or the classification. We're saying what happens for someone that has committed a crime for them for hiring. But the conversation that we just had does not have anything to do with changing classifications or punishment, correct?
Mr. Chair and Delegate Price, yes, that is correct. This is just for barrier crimes purposes only.
Awesome. Thank you. And last question, Mr. Chair.
Delegate Price.
As we talk about the waiver process as has been put forth for the drafting of this first draft, do we have an idea from the agencies what a potential timeline would be? Because I know we've heard from stakeholders, A, who want to hire, and B, who are ready to be hired, but it's these laws that are preventing that. They're interested in working now. So do we have any idea from the agencies or anyone, how long would this process take for the waiver process?
Mr. Chair, Delegate Price, yes.
Yeah.
We have heard from the Department of Health, which, and I can let Rebecca add on to this if she'd like, but they requested the 2-year timeline because they were at this point, my understanding is they don't have any people in their central office that are dedicated to working on barrier crimes right now. So they would need some time to be able to hire and develop the process. The Department of Social Services, in my last conversation with them, so I'm not sure if anything has changed, did indicate that they do not want a delayed effective date. So we might have to do some different delayed effective dates with different organizations just because some of them are set up a little differently. I'm not sure about DBHDS and DOE yet.
So I'm sorry, I did not specify in my question, so I apologize. Thank you for that answer. I'll ask it a different way. Once the systems get established and I'm applying for a job, do we have any idea in how much time this would add to my application process for a position in order for me to get the waiver, how long it would take once I apply for the waiver? That I'm sorry, that's what I meant as opposed to delayed enactment.
Oh, sure. Sorry, Mr. Chair. Delegate Price. Yeah, sorry, I misunderstood that. No, we're not sure about what that time period would be yet. The agency people would probably know better than we would how that internal process would work with them.
Chair.
Any other questions?
Mr. Chairman.
Yeah, Senator Serval.
Thank you, Mr. Chairman. Anna or Sabrina, so yeah, that also just makes me wonder, a lot of times when I've created new processes in the code, I've put deadlines in it. That there has to be processed within a particular period of time, et cetera. And I would imagine that with regard to what we're doing here, they're likely to get like 1,000 applications on the first day. So deadlines to me seem a little dangerous, at least for the initial slug they're going to be getting. But did they have any sense? Have they looked at any other states where other states have sort of opened the gates to something like this and then seen what happened? Because, for example, I know that when it came to driver privilege cards, which was, we passed that in the 2020 session, which opened up driving privileges to 300,000 undocumented people. DMV had some projections based on other states that they were going to get this massive tsunami. And as of today, the law has been in effect 9 months, and they've only seen like 40,000 people or 30,000 people come through. So it hasn't been quite the tsunami of chaos that was projected. I mean, have we looked at any of that and sort of ascertaining perhaps how to phase this in? Like whether or not we ought to say for like the first 6 months, the only people who can file are people that have convictions that are, say, more than 10 years old. And then for the next 6 months, it's 5 years old. And then the next 6 months, it's people that have barrier crime convictions like the last 5 years or anything like that. I mean, have you got any feedback or thought about any of that in terms of how to do this so we don't get some big, massive train wreck at the beginning and we have like 500 people calling our offices wanting to know why their thing hadn't been processed yet and they need to get a job like we have with the unemployment situation?
Mr. Chair.
Good. Anna, go ahead.
So we've looked at other states to the extent that we know that other states do the waiver process. I haven't looked at how things happened at the beginning when they did the waiver process. So I'm not sure about all that, but we can certainly do tiering crimes. And in fact, that's something that we had brought up at the last meeting. And I don't think the members were super interested in doing that long term, but that is definitely something that we could do at the beginning. And I think that would make sense. But I don't have any data about that from other states, how they did that, but we can certainly try to look into that.
Elliot Mullen.
Thank you, Mr. Chair. Mr. Chair, just a quick comment. The fewer delayed enactments, in my opinion, the better. If there isn't an agency asking for it, I certainly wouldn't want to put them in. The fewer the better. That's just my comment.
I agree with you completely.
But one of the questions that I just sort of had, maybe this is for Anna, maybe this is for the ether or for somebody else who's better counseled than I am. I'm envisioning a situation where someone gets a waiver and then either doesn't get that job or goes to another job. Do they have to apply for a waiver for every time they go to another job? Or does that waiver essentially go with them? Or does it stay with the job?
Good question.
And do they have a piece of paper that sort of goes with them? Is there a waiver card? How is that going to work? Because in my mind, I'm thinking of this as there's a waiver that rolls with them.
Anna?
Mr. Chair, Senator Edwards, yes. So the waiver, the one kind of thing with this that I know might not be super ideal is that the waiver, it won't, well, unless, I don't know if the agencies would set it up this way, I don't think they would. The waiver would be, I think, the way we have it drafted for just for jobs under a certain department. So if you have your waiver and you work for early child care under the Department of Education, if they set up their process that way, the waiver might be transferable there, but I don't think the way we have it addressed now that if you had a waiver for early child care and you wanted to go over and work at a nursing home for the Department of Health, I don't think that it would transfer to that. Because since what we're doing is we're giving, since they're just such different populations we're working with, we're trying to give the agency some flexibility because I think there might there might be some divergent ideas of which crimes they're willing to allow a waiver for versus not. I'm not sure we're going to get everybody on the same page for that. So I do think it wouldn't, and I'm not sure how the piece of paper or whatever would work. That's why we're trying to let each agency kind of develop their own process.
Maybe in the process, if each agency does their own, they could look at whether or not they could, take care of the issue. If you get it from one agency, it should apply to the other. Maybe that's something they could look at.
Yeah.
Mr. Chair, also something I didn't mention earlier. So the parameters that we put around this in subsection H were kind of just a baseline. You guys can, or you all, excuse me, not you guys, can add more parameters around this process if you would like. We're happy to add more rules and requirements to this. That's just, we were kind of trying to create a baseline for how they would create the waiver process. So we can certainly add more.
Mr. Chairman.
Yeah, Senator Sherrill.
Thank you, Mr. Chairman. I would just note that I think making these waivers transferable between agencies could be problematic, because I could see one agency saying it's okay to allow this person to counsel people who have drug problems, but not okay for them to be around children. And so I'm not sure we want to have a blanket, reciprocity on these things. I do note, however, that one of the approaches I'd recommended early on about going in front of the judge where you could do it all at once might have solved that problem, but we didn't go that route. So, but I see some issues associated with transferability. I did have one other question for Anna, and that was with regard to people. I assume as they go through this process, they're going to submit a lot of information to these agencies to try to show why they ought to get this waiver. And if I were a person submitting things, I would want to probably be able to give them some pretty detailed personal stuff, maybe even some medical records. And I wonder if all this stuff is public record, whether that might dissuade people from providing things or providing all the information they need to provide. For example, things that might otherwise be subject to HIPAA or otherwise that they don't want the world obtaining by FOIA, or some reporter obtaining by FOIA or something. And I was just curious, sort of, if you all looked into sort of how much of this is subject to FOIA versus how much isn't, and how other states have sort of achieved a balance on that to make sure that, we have an adequate amount of information that's being provided, but also an adequate amount of public accountability. So if there's a concern about a waiver that was granted, that people in the public can look and feel comfortable that the appropriate decision was made and there's no favoritism that was, done or anything like that. I mean, have you all, I don't remember or didn't see anything in here about any of that. And I'm just curious how that side of it plays out once these applications start getting processed.
Anna, Sabrina?
Mr. Chair, yeah, Anna, I'll grab this. Mr. Chair, Senator Surivel, that is one of the considerations that we, kind of one of the outstanding issues that we have that we want to address. So that was where we need a little bit of direction from the joint subcommittee, because there could be FOIA concerns with some of these sensitive documents for sure. So if we would want in the next draft to include some kind of carve out for specific documents that would be included with a waiver application, we can absolutely do that. So that was one of the outstanding issues that we wanted to address today, regarding what is FOIA-able and what it should not be.
With regard to the transferability, there's another issue. Some crimes are barrier crimes in some categories, but not in others. That's different than crimes that are barrier crimes in all categories. It seems to me if somebody gets a waiver in one category, say Department of Education or whatever it happens to be, that they shouldn't have to be jumping through extra hoops when they want to get a job with another agency like the Department of Social Services, assuming that the original barrier crime was the same. And I think the agencies could take a look at that issue.
Mr. Chair.
Yeah, Sia.
Yeah, I'm definitely appreciative of the work that's being done, because we are trying to transform a system that has many agencies at the table get that. I'm wondering, because of other things that we've done, let's say healthcare or housing, there were navigators that were available for those that were trying to go through the process to help them at each step to know what to put in, when to put it in. If you're going for this agency, it's this. If it's this agency, it's that, so that they're not ping-ponged back and forth. I don't know how reasonable of an ask this is, but I wonder if we were to create a navigation system where there were people that could help walk folks through, if it's going to be this waiver process. What would the cost be? What could that system look like? I've heard amazing feedback from those that are having to navigate enrolling in healthcare, depending upon their situation, but also some of the other benefits that are available based on individual situations that, not everyone, but a lot of folks who are finding themselves trying to go through this waiver process, it might be all online. They might not be, tech savvy. It just seems like as we're creating a system, we're also creating unintended obstacles. So I'm just wondering what might be something that we can help people to navigate through it.
Does anybody know how many people are going to be involved in this application process for a waiver? Any feel for it at all? Because it sounds like if it's a big issue, that the navigation system makes a lot of sense. I don't have any feel for it.
Mr. Chair, yeah, I actually don't either, since that's probably more of an internal question for the agency folks. I'm not sure if any of them have an answer to that at this point, but I do not.
It's certainly worth looking into. I mean, the idea of driver's licenses, there were like 440,000, I think Senator Serval said, they got it, and 300,000 people were potentially involved. That's a lot of people. I don't know if we can have that kind of numbers at all. I have no idea. Maybe we could ask the agencies too to look into what they think.
Mr. Chairman.
Yeah, Senator Serval.
Thanks. There are, my understanding, it was 1.6 million Virginians with criminal histories, and obviously all those aren't barrier crimes, and all those don't want to work in these industries, but it's definitely in the thousands. There's no question about that.
Yeah,
Mr. Chairman, I had another technical question for Sabrina or Anna.
Yeah, Senator Serval.
I didn't see it mentioned in here, but it about an appeal process, but that might be already because this is subject to the Administrative Whatever Act, where you appeal to a circuit court. Is there an appeal process available to people who are denied a waiver, but don't feel like they were properly denied?
Anna?
Mr. Chair, Senator Serval, we do not currently have that in the draft, but that's something that we could add if you would like.
Hey, Mr. Chairman.
Yes, Senator Serval.
Yeah, I don't know what the agencies would think would be a proper appeal process, but it seems to me that having a circuit court judge review it might not be a bad check and balance on it. But I don't know what's done in other states. I know we have, for example, I know circuit court judges review, procurement issues that happen at local government. There's other things under the Administrative Process Act. I think employment decisions where government employees are fired or not fired properly and improperly that can go there. I think.
Sure.
So.
I think Ms. Allen is raising her hand.
Okay.
Seems to have an answer. She looks like she's.
I'm not seeing anything. Somebody.
Ms. Allen is raising her hand. I think she's.
Rebecca Allen? Yeah, okay. Go ahead.
Thank you, Mr. Chair. In response to that question, we have had preliminary discussions at the Virginia Department of Health, and I can bring up more details about this in the discussion section. But one of the questions we had back to Anna and Sabrina was this waiver process, supposed to be contained in our regulations? Because in our discussion about it, we felt that the preliminary decision on an application, grant or deny, if someone was aggrieved by that decision, that they were denied, that we could then go to an informal fact-finding proceeding under section 2.2-4019 of the Administrative Process Act. And if they are still aggrieved following that informal fact-finding proceeding, the APA does afford them the right to appeal that decision directly to circuit court. But that was just a discussion that happened within VDH. I can't speak to what other agencies have discussed yet.
That makes sense. Yeah, Deli Mullen.
Mr. Chair, I think that's what Senator Serval and I were assuming would have occurred, but that's not technically written in right there, right now. I think that was sort of assumed would be part of the process, but is not actually written in right now. Is that, Ms. Moore, is that correct?
Mr. Chair, Doug, yes, we haven't put it in yet. We've certainly talked about it, and we actually are very open to changing that language. But we kind of did it this way the first time because this, it's just a preliminary draft, and we didn't know, how detailed we would want to make this process. But we can definitely require each department to include it in their regulations.
And I think that's what Senator Servo and I were assuming would have occurred, but
Right. Okay.
But I would open that up to anybody else. That wasn't even a motion. That was just sort of a discussion point that I think Ms. Allen and others.
I think everybody basically agrees with this, don't they? Everybody disagree? I think it makes sense. Put something in there about that to make it clear. Okay.
Mr. Chair, yes, sir, we will.
Okay. Anybody
Mr. Chair.
else? Sia?
Delegate Price. Yes, I had a question going back to something that I think is before us. I think it's the appropriate time, but talking about the FOIA issues for the personal information. And I just wanted to know, because it seems kind of onerous if we don't quite know everything that's going to be needed from the agencies, then we don't even know what we're choosing from in order to not be FOIAble or FOIAble. Is there any way that we can get an idea? Like, I don't think anything that would be covered under HIPAA should be FOIAble, but just trying to get some input on that. If you're looking for a decision from us, I think we need a little bit more information before we can just say, yes, this, no, that. So if this is the appropriate time, I'd be willing to hear from some of the agency folks on what types of information would be required.
Yeah, that's a good question. All right, Anna? Sabrina? What are they looking for?
Mr. Chair, I don't know the agent. They'll have to answer that question. We're not sure about that.
Yeah.
Mr. Chair, I think Ms. Allen briefly is raising her hand again. She can at least answer for one of the agencies.
I see Rebecca Allen. Sorry.
Thank you, Mr. Chair. Again, based on preliminary internal discussions, we had raised the FOIA issue with Anna and Sabrina. So previous to my employment at the Virginia Department of Health, I worked for Board of Accountancy, and just with my familiarity for the crimes of moral turpitude issue that we looked at there, it tends to be rehabilitative factors that we look at. So depending on what the particular crime is, it could involve medical records, particularly if they've been in therapy or in any sort of substance abuse recovery programs, which would, I don't think that would be necessarily a barrier crimes issue for us for VDH, but it was for Board of Accountancy. I will, and I did point this out to Anna and Sabrina, that for Board of Accountancy, DPOR, DHP, they do have an exemption from FOIA. It's not found in FOIA. It's actually found in Title 54.1 that broadly exempts applications for licensure. And since the evaluation of moral character is a part of those applications, the decision on the application is obviously public, but the application and any attachments to it were exempt. So that was one suggestion that VDH had floated back to Anna and Sabrina, was considering taking the models from DHP and DPOR and Board of Accountancy and building from that, particularly at this point in time, since we don't know exactly what the rehabilitative factors would be, that the ultimate decision and any rationale or reasoning that attaches to that decision, that would be public, but the application and any attachments that the applicant filed would not be.
All right. Any other questions?
Chairman.
Yeah. Okay.
Mr. Chairman.
Yeah, Senator Sherrill.
Thanks. It seems to me that the application itself ought to be subject to being obtained. However, there ought to be maybe a category of things you could attach to it that would be subject to not being produced. You know, that's how we kind of do it in court, right? There'll be like a protective order, and if there's stuff you want to submit the subject to protective order, you stamp on there. This is the stuff you can't share around the world. So it seems to me there's some kind of a process in there where somebody could designate categories of stuff that aren't going to be disseminated. But the application itself, where somebody applies and says, here's my name, here's my address, here's what I was convicted of, I'm applying to have this removed. that basic thing ought to be a public document. After that, if you got a letter from your therapist, or you got, something showing you completed substance abuse therapy or whatever therapy, that kind of stuff. And it wouldn't, that kind of stuff isn't necessarily covered by HIPAA, because as soon as you give it to somebody, it's no longer covered by HIPAA. But if you pulled it out of a doctor's file, it's HIPAA. But maybe it ought to just be clear that certain categories of information that are submitted pursuant to a certain process designated by the applicant as personal, sensitive, whatever, that stuff goes in a box that doesn't get out. It seems to me that might be a potential process.
All right, like social security numbers, that type of thing. Okay.
Mr. Chair, James Abrinio here.
Yeah, James.
Thank you. And perhaps Senator Serval could kind of expound upon that, because I'm wondering if what you're saying, perhaps there's almost like a cover sheet with just the biographical information, the charge, and then seeking it. But as far as, hey, I did this, this, and this, even if it's not a medical record, you'd still agree that should be confidential.
Yeah. Yeah. Okay.
Okay.
Mr. Chair.
Yeah. Price.
Yeah, so Senator Serval, with the work that is happening on another commission that you're on, or some of the bills that were going on with expungements, how would that interplay? Would the application go away once the charge would, like, let's say I'm applying for a waiver today, but in 2 months it gets expunged. What happens to that application and its public availability?
Sorry, Mr. Chairman. So,
yeah, Delegate Senator Serval.
So, Delegate, are you asking about a court process? Like, if you seek to have a criminal charge sealed or expunged, are you asking what happens to that?
I guess, Mr. Chairman and Senator Serval, I'm just making sure if we're creating an application process that has on it public information about previous charges, that we also are making sure that it's included in any of our further work, for whether it's an automatic expungement, a court expungement, but that would that paper that we're creating in this process be covered under the other laws that we're creating for it to go away once somebody's record has been expunged?
Senator Serval.
Well, Mr. Chairman, first of all, an expungement only applies to non-convictions. So something being expunged wouldn't be a barrier. So what we're talking about is stuff that's being sealed, I think. And the sealing law goes into effect July 1, 2025. And what that law says is that if any conviction, which is class 5 felony all the way down to traffic offense, is sealed either by petition or automatically, that the act of sealing it means it's no longer a barrier crime, and you would not need to go through this barrier crime process because the sealing takes care of that. I don't believe there's anything under the sealing statute that says because there was no waiver process. This waiver process didn't exist at the time we wrote the sealing statute, so we didn't think to have these records sealed.
My apologies, Mr. Chair and Senator Serval. I used the wrong term. So I am talking about the sealing, but what I'm making sure, since we are creating something new, if I am applying for a waiver at some period of time prior to it being sealed, that this new application that I'm filling out through this process that we're talking about would be covered under what is sealed once I get to that mark.
Mr. Chair.
Delegate Mullen.
No.
Mr. Chair, may I answer the question?
Yeah, sure.
Mr. Chair, I would answer the delegate. They touch on different crimes, because none of the crimes that we would be talking about under the sealing statute that Senator Serval was working on are under the crimes that we're talking about here, because they're different silos of crimes.
No,
Senator Serval.
For the automatic sealing, you're right. But for the petition-based sealing, you could seal some of the crimes we're talking about here by petition.
But that wouldn't matter because they're already going to be going under the barrier crime section anyway. So why would you have a sealed barrier crime anyway here? Because it's already sealed. Why would you be going through this?
Yeah, if it's being sealed, it wouldn't be a barrier crime, right?
That's right.
Okay,
Well, I
so
think
I'm going to
Mr.
try one more time if I could, Mr. Chair.
Yeah, can I try and give
Why
an
would you be going
example?
through this process? It's already sealed.
Your delegate's price.
So what I'm asking about is an application that I'm applying for a waiver prior to anything that I've done being sealed.
Right.
This is a creation of a new public document. We're saying that the application should be public. I'm making sure that that public information would be included should I get to the point of things being sealed, or are we opening someone up to having a public document that falls into the category where Senator Serval just said is available online and there's no point in sealing things if we're just going to have it all out there.
Mr. Chairman, could I try and give an
Senator
example?
Serval. Yeah.
Thanks. I think what Delegate Price is saying, say I have a conviction for cocaine possession, and that conviction might not be eligible for sealing until maybe like 2023, but this law goes into effect 2025, and maybe before I can apply to get it sealed, I apply to get the barrier crime lifted with one of these agencies. And then the agency says, okay, you can go be a child care worker now. And then 2030 rolls around, I file a petition to get my cocaine conviction sealed. A court grants it, it's sealed. It vanishes from my criminal background history. But there's this other public record out there saying that I had a cocaine conviction and I got this thing sealed 5 years earlier. But the sealing didn't wipe that out. And so I think what she's saying is we need to make sure that if we do the sealing, this gets picked up also at the same time, so it's not all out there still, right?
Okay.
Delegate Mullen,
Thank you.
everybody clear? All right.
Now I'm following her. Okay, so she's talking about that 2-year period. Yeah. Okay.
10 years, whatever. But yeah.
Okay. All right. What's next?
Actually,
Anna, Sabrina, where are we?
Mr. Chair, public comment. I believe you had a good number of people signed up for that if you wanted to do that now.
Yeah, okay. Who's up next? I think I have a list, I think.
Yes, Mr. Chair, you have in front of you, I believe, a list of folks who have signed up, and I think that we have 1 or 2 more since then, and a couple of them didn't make it into the queue. So I propose at this time to just start moving people out of the queue and into the room, if that's all right with you, Mr. Chair.
Okay, Melissa Brown, is that number 1?
Sure, we can absolutely. Melissa Brown, yeah, you're in here just a few times, and I'm going to move the first one in. I suspect that you have shared your sign-up link with several other people, so I'm going to move Melissa Brown in presently. And
I haven't shared. I don't know if you shared it, but I haven't.
let's see. This is okay. She has helpfully indicated which is the appropriate one.
Okay.
So Melissa Brown, I am moving you into the Zoom room presently. And Ms. Brown, you're welcome to begin your testimony at any time.
Go ahead.
Yeah, there you go. Hi there. Thank you for letting me speak today. Good afternoon, members of the Barrier Crime Committee. My name is Melissa Brown, and I'm a person in long-term recovery from addiction. Due to the extensive list of barrier crime, Virginia's behavioral health workforce, which includes peer services, clinicians, counselors, physicians, is operating with limited human capital. Plainly, we have a lack of qualified staff across the state to care for people suffering with mental health and substance use disorders. Can you help with this shortage by changing the barrier crime law to be less antiquated and more relevant to our current needs in Virginia? The current barrier crime law does not allow me to work in a state licensed facility directly helping others gain freedom from addiction. I have been working or volunteering in the field of addiction for over 8 years in one form or another. By being a sponsor, a family member, a church member, a mentor, a counselor, a peer, and a friend. I currently work for a substance abuse treatment facility as a community outreach representative, making relationships between community partners to give individuals suffering with this disease options for treatment that can save their lives. On any given month, the work I do in the community helps hundreds of people find treatment for substance use disorder or mental health disorder that best suits their needs. I know that I'm making a difference, but I went to school to help people directly, one-on-one, not indirectly. I have been in recovery from addiction since March 14th, 2002. I committed crimes in 1999 and 2000 directly related to my 13 years of substance abuse. One of those crimes is on the barrier crimes list. Subsequently, I went to prison, completed probation, and have become a productive member of society. Can we for a second recognize that the 3 largest institutions currently providing psychiatric care and substance abuse services in the United States are prisons? It should come as no surprise that Virginia peers with mental health and or substance use challenges have had firsthand experiences with the criminal justice system like myself. Can we also recognize that for us as a society to help this population become productive members of society post-release or before they ever enter the criminal justice system, we must change the inhibitive laws that do not allow people with lived experience and have committed one of these crimes to be able to help people that are still suffering. Immediately post-incarceration, I finished college at the University of Mary Washington with a bachelor's degree in psychology and received my certification by the Virginia Board of Counseling to become a certified substance abuse counselor. I was unaware until I started looking for employment that I would not be able to work in a direct care position for a state licensed agency. I believe I and the people in recovery like me are some of the most qualified people to be able to help others that are struggling with the disease of addiction or mental health disorders. If you personally know anyone that's suffering or who has suffered from alcohol, drug addiction, or mental health disorders, you know that they need community to recover. I am someone that can be part of that community if allowed, not just as a person in recovery myself, but also as a qualified, certified counselor if the law will change. I'm living proof that support from community of recovering people changed lives. In closing, we have not had any real positive movement on this law in years. A list of screenable barrier crimes was enacted a few years ago. However, that has not changed our staff shortages in this field, nor has it allowed much movement in allowing all people in recovery from substance use disorder or mental illness to be allowed back to our communities in a way that could be real help, not just in our current crisis, but in the future. I recognize the preventative measures of the screening process that was enacted a few years ago. However, the list of screenable crimes is very short compared to the barrier crimes list. I ask that our elected representatives recognize that people with lived experience who have found stable recovery should be valued for their ability to guide others in similar situations rather than be excluded from the workforce. If we believe in second chances, if we believe in restoring rights, then we need to change the barrier crime laws. The unintended effects of barrier crime laws have created an unbreakable glass ceiling for many Virginians interested in working in state licensed behavioral health care facilities. I strongly encourage our elected representatives and people in this committee to review the current list of barrier crimes and reduce these limitations by making the barrier crimes screenable for state mental health and substance use agencies within 10 to 5 years from the crime, depending on the severity of the crime and their own personal recovery. We do recover. It's been 19 years since I've committed a crime. I'm an educated person in active recovery, a taxpayer, a homeowner, a community member, and a dedicated advocate for recovery. Please move forward to eliminate the stigmatizing and outdated law that was enacted during a tough on crime era that was passed with good intent, but has had many unintended consequences. Thank you for letting me speak today.
Any questions of Melissa Brown? And thank you, Ms. Brown, for coming before us and giving your testimony. We appreciate it very much. Any questions of Melissa Brown? Okay. Thank you, Melissa Brown. We, again, appreciate very much your coming forward. It's very impactful. Thank you.
Thank you.
The next person that I have on the list is Sheba Williams. Is that the next person?
Yes, Mr. Chair. I'm moving Sheba Williams into the Zoom room presently.
Okay.
And Ms. Williams, you're welcome to begin your testimony presently.
Good afternoon. I will decline today, but I appreciate you all.
Okay, thank you. The next person is another Brown, Isaac Brown.
Mr. Chair, Isaac Brown isn't in. With your permission, I could just call the next person at the top of the queue.
You do it. You do it. Okay.
Yeah. Yes, Mr. Chair. Angela Inglet, I'm about to move you into the room, and you're welcome to begin at any time. Holly Boswell, you'll be next. Angela, I ask that you unmute yourself and begin your testimony.
Okay. Angela Inglet, is that it?
Can you hear me?
Yeah. Thank you for coming.
Perfect. Thank you. Chairman Edwards and members of the committee, my name is Angela Inglet, and I'm here on behalf of Prison Fellowship, which is the nation's largest Christian ministry to prisoners, former prisoners, and their families. And first, I'd like to convey our appreciation for the work of the study committee on this issue. We are so grateful to see this body recognize the God-given dignity of Virginians with a criminal record. And we applaud the development of policy to help these individuals live out their potential as employers and parents and neighbors and citizens. And so we look forward to more closely reviewing the proposal that's been discussed here today. Prison Fellowship believes that public policy can advance both second chances and the safety of our communities. With these goals in mind, we argue that ongoing restrictions post-incarceration must be directly related to public safety and the person's offense, while also accounting for evidence of rehabilitation. We find that often collateral consequences that fail that test can needlessly undermine the reintegration process. And that's why we are so grateful that this body is reevaluating the current barrier crime list. And we agree with the removal of barrier crimes that are not directly related to a specific role or position or to public safety. We also support a waiver process that would consider an individual's rehabilitation since the time of their conviction, because after 4 decades of work with prisoners and former prisoners, Prison Fellowship knows that people with past convictions can and do go on to live peacefully and productively in their communities. And we know that that personal transformation should be acknowledged. So again, we look forward to more closely reviewing the legislation discussed today, and we appreciate the committee's diligent work on this issue. Thank you so much for your time and the opportunity to speak today.
Thank you, Angela. Any questions? Let me say, if you have any suggestions on the legislation, we welcome your comments in writing or any other way. Okay?
Thank you so much, Chairman Edwards, and we will certainly respond with feedback to this proposal.
Great. Okay. Thank you. Next.
Ms. Boswell, you're welcome to begin. Jamin Gale, you'll go next.
Hello. I was just, I'm kind of nervous. I've never done this before, but I just wanted to find out about how we can change the burial crime laws. In 2002, I was addicted to alcohol, and I'm still in recovery, but during a thing of a big change of events, divorce, custody, and everything else, I just went downhill. I was a nurse, lost my children, I went to prison for DUI and assault on police officer, and the assaults were directly related to the drinking. And I have since got my bachelor's degree in psychology, and I was in a position at Western State Hospital until my background check came back, and they had to let me go, which they were pretty sad about. Right now I'm working at a nonprofit place in Charlottesville, which is on our own. And I just would like to be able to help people, reach a level of so they can feel like they are needed and that they're valuable, because, through my addiction, like I said, I had lost a lot, and it took a long time for me to, I guess, decide that life was worth living. And I just wanted to see, maybe if there could possibly be a change, eventually, so that I could probably go back to work with Western State or the CSD. And thank you. Sorry for being so nervous.
Well, thank you very much, Holly. We appreciate your comments. And again, if anybody wants to submit anything in writing to us, that'd be fine too. We appreciate that. Any questions of Holly Boswell? Thank you, Holly. Thank you again for being here. Okay, next, Sean.
Jamin Gale has been unresponsive, so I'm asking that Mark Gonzalez please go next. David Skiles, you'll follow.
Mark Gonzalez.
Mr. Gonzalez, you're welcome to unmute and begin your testimony.
Thank you for having me. Can everybody hear me okay?
Yes.
I wanted to say thank you first off, and commending the committee for making huge strides towards this reform. I know many people who have been looking forward to it for a long time, and it's good to see that there's a lot of action being taken. One of the things I wanted to discuss is that if the legislation were to provide the departments with authority to establish a waiver process, there should be some minimum standards that ensure equal treatment of the applicants. It's one thing to permit each department to create policies and regulations that pertain to their own hiring initiatives, and it's another thing entirely to extend those processes to non-government agencies such as private licensed providers. Any restriction of the hiring of previously convicted persons should be codified in law in such a way that arbitrary interpretation or implementation by the departments or their boards is minimized. Leaving it to each department to establish regulations about which crimes shall be barred puts the department in a position that it's responsible for creating the restrictions on both private employers and their potential employees, not just their own potential department employees. Currently, the department's primary mechanism for regulation enforcement is through state code. For instance, DBHDS has licensing specialists that oversee licensed providers and hold them not to a set of arbitrary rules that they hold as internal policies. They hold them accountable to state regulation, which is actually in state law. So providers can actually look at it and reference it in terms of this is a legal restriction that we must adhere to. So one of the questions that it begs is what prevents the department or any of the departments from becoming just as restrictive as the current legislation already is? If the departments decide, well, now that it's off the table in terms of it's barred employment because it's a law and it's up to us as a department. I'm not saying anything about anyone at any department because I don't know anyone there, but it's not too tall a tale to say that, well, maybe somebody might decide we'll just say that all of those things are barrier crimes, and then we're essentially all this effort that this committee has put in goes right back to where it started in the first place, where people can't get employed because nobody wants to allow the doors to be open. And I believe that without a floor, some sort of minimum, there's no way to ensure that the efforts here come to fruition. I believe there should be no bar on who can apply for a waiver. I know one of the things that the proposal indicates is that maybe the departments pick which crimes become exempted automatically, or which crimes are still barred automatically. But truthfully, a case-by-case approach is the only reasonable manner in which a person's voice might get heard. The departments are not privy to the details of any crime committed or any circumstances pertaining to a citizen's current disposition. And the only way they'll find out, and the only way to provide fair treatment across the scope of convicted persons, would be to permit the person to have a chance to be heard and apply in the first place. Closing the door to the applicant puts them outside the scope of being able to explain why they want the position in the first place. Goes back to the hide the box sort of mentality that a lot of states took in order to say, look, we're not going to ask you until after you apply. I think that's still a good way to consider how we open the door to people who might have previous convictions. I know that we want to explore outside states and how they manage waivers, but we already have a similar approach in our state code concerning things like professional and occupational licensing. So in State Code Title 54.1, Section 204, we see an example of how this is already being applied. Specifically, the code outlines how prior convictions should not abridge the rights of an applicant unless the relevant boards find the person unfit for the occupation or profession. There are 9 points that department uses for these decisions, and it's listed in our legislation. And it's this section of code that doesn't prohibit any previously convicted person to apply for a license and requires the boards and departments to evaluate each application being submitted. So we just heard Ms. Brown earlier share her testimony, and we hear that. We hear that people can go to school, turn their lives around, raise families, gain experience professionally, and then get ready and take a certification, become licensed, and then you can't get a job to do direct care. I believe that a similar approach concerning the waivers can be adopted if the departments are to oversee a waiver process, allow a minimum standard as far as the criteria for barring, or the criteria for not barring, but the criteria for consideration when receiving an applicant who has a previous criminal history. I agree that the use of the Administrative Process Act could also be used to establish a way to appeal decisions on a case-by-case basis. That should be something offered to everyone, even if we evaluate things on a case-by-case basis. I'm sorry. I also think that it's important to point out that for regulated occupations that require licensing, right? So we're talking about nursing, social work, or even becoming an attorney. The review process is there and available to anyone who's met the educational and professional requirements. So you go to school, you take the classes, your biologies, your maths, your everythings, your sciences, you graduate, and now you want to become a nurse. The board has to be able to allow you to apply. There's no barring for you to apply. We've heard many times, even lawyers go and become, ex-felons become lawyers because a board is willing to hear the person first, not make a decision just because they have a criminal background. So again, there needs to be a minimum, and there needs to be a criteria for consideration. For what doesn't make sense to me is for direct care positions, which are usually non-licensed occupations, direct support professionals, that sort of thing. Barrier crimes are immediate showstoppers for anyone seeking employment with public and private organizations. So it doesn't matter if you're applying for a job at the Department of Health or the Department of Education. These things are showstoppers right off the bat. There is no applying. I mean, I guess you could technically still apply, but the stigma and knowledge that everybody already knows is don't even bother. And by allowing the departments to bar certain applicants, it doesn't make it any easier for those people to seek employment. And many of those jobs, right, so direct care positions specifically I'm talking about, They're transitional jobs that could lead to experience that may be meaningful for professional licenses later. But again, they can't gain that experience even if you go to school and you become a nurse, or you graduate and the board passes you for nursing. It's still going to be hard for you to become a nurse without some relevant experience, some healthcare experience. So if the departments prevent people from applying to non-licensed positions, they may not be able to develop the skills needed to demonstrate professionalism and rehabilitation in the first place. So that's what I wanted to share. I wanted to thank everybody for your work, and keep going. Thank you so much.
Thank you, Mark Gonzalez. We appreciate it. Any questions of Mark Gonzalez? All right, thank you very much. Next person, Sean.
David Skiles, please begin. Nathan Mitchell, you'll be next.
Mr. Chair. Mr. Chair.
Yeah, Delegate Mullen.
I've been told that Mr. Skiles has nothing that he wishes to add to this conversation at this time.
All right, next person.
Thank you very much, Delegate. That being the case, Mr. Mitchell, please begin.
Nathan Mitchell. Nathan Mitchell, welcome.
Welcome, Mr. Chair, everybody. I really have nothing more to add as well. Thank you for doing the work that you're doing. It's fantastic work, and just listening to you all talk about the waiver and how that's going to play out. You have a lot of work ahead of you. So people in the recovery community, I'm a person in recovery from a substance use disorder. We're looking at you to do the right thing and to make sure that we can continue to help the people that we work with. So thank you all.
Thank you very much. Any questions? All right, and Sean, who's next?
Next will be Randy Riffle. I'm attempting to promote him to panelist presently. And if not, our final today will be Thomas Jackson.
Thomas Jackson.
Mr. Chair, Mr. Riffle is from my office. He does not need to.
Understood. Thank you very much, Delegate Mullen. That being the case, we'll see if Thomas Jackson is available. And
Thomas Jackson, are you here?
He is entering the room now, and this will be our final member of the public to speak today, Mr. Chair.
Okay. Thomas Jackson. Is there Thomas Jackson here?
I think that he has exited the Zoom room, and I assume that means he would not like to speak. That being the case, Mr. Chair, there is no one else queued to speak.
Okay, Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, I was swayed by some of the things that Mr. Gonzalez was saying about the possibility of us giving some of the agencies, in essence, veto authority over our intent. Is there something that we might be able to hear from council about that possibility?
Okay, Anna or Sabrina?
Mr. Chair, Doug, I'm sorry, can you explain which point you were talking about more specifically?
So the possibility that we set up this structure of them being able to sort of decide which crimes they're going to automatically not have hearings on.
Mr. Chair, Doug, I think, and Sabrina, correct me if I think that's kind of how we already have it written. Is that they have to, now we're going to be changing it. I think we're going to be making them put this in the regulations now.
Right.
But as it's written now, that's what they're supposed to post on their website to make clear what people can actually apply for or not. So we'll definitely make sure that that's very clear in the next draft as well.
No. I understand that, but I mean, that's sort of a policy decision that we're making.
Oh,
that we're allowing the agencies to make their own list.
Oh, yes, sorry.
So I'm sort of opening that up to the group, that's an issue that Mr. Gonzalez raised to us, which is that we as a group have made a list of crimes that we then send down to them, and then they get to make their own list again, each agency in particular. Is that correct, Anna?
Mr. Chair, Delegate Mullen, yes, that's correct.
So it almost is, as Mr. Gonzalez says it is, that if they wanted to thwart the nature of what we're trying to do here, which is expand access someone might have to these jobs generally, a specific agency could create regulations under this whereby, in essence, their list is so long that no one ever really gets to have a full hearing.
Well, they can't. The agencies can't add to the crimes we've already established. Could rather find ways for people to get a waiver. Nevertheless, isn't that right? Go, Mullen. Go ahead.
Well, I think that's kind of what Mr. Gonzalez was saying, and Anna, am I misunderstanding here? Am I going off on a lark? And
Mr. Chair, Delegate Mullen, no. So, I mean, basically how we have it is that we have our long, huge list of barrier crime provisions in 19.2-392.02 that we haven't gotten any indication right now that you all want to change. And then each department, in each of their relevant sections, they all have kind of different rules. Like, for example, for the Department of Health, I think that the only crimes that are barrier crimes for them are the ones in Clause 1. So their waiver processes are only going to be for the crimes in Clause 1, whatever they create. That's all that, they're not going to be able to add to that list any barrier crimes or anything. And then, same for each of the other agencies, depending on what their crimes are. And we are giving them flexibility as far as within the barrier crimes list. We are giving them the ability to say, okay, maybe in the barrier crimes list, Department of Education, I'm sure, is going to make it so that any sort of child sex related crime, you cannot work with children. But beyond that, I don't anticipate that there is going to be, I don't think that the agencies will have the ability, and I don't think they have the desire either to undermine what we're trying to do here. I think they, at least from the meetings, what we've heard in the meetings, they have an interest in trying to make this a more flexible process as well, while also trying to balance protecting some of the vulnerable populations that they work with. But any of the agency folks, please speak over me if you have something to add to that.
Anybody from the agency want to comment?
Chairman Edwards, this is Stacy Pendleton at the Department of Behavioral Health and Developmental Services.
Yes, Stacy.
And Delegate Mullen, I think, this is really a workforce issue, and the agencies that have been involved are really looking at this as a way to enhance the workforce. We certainly would be working with all of our stakeholders, private providers, advocacy groups, the community service boards in the waiver process development. So I think there would certainly be all of that input in what that process looks like if we develop that, that I think would help address that public comment.
I think at least I understood somebody saying that, for example, the Bar Association says you now can come back and practice law despite the fact that you had 6 months in prison for something or other, that the agency could then, not necessarily in the law practice, but in some categories, say, nevertheless, we're not going to let you do it.
Right.
And so they need to kind of look at, if there's an agency that regulates a certain category, certain psychologists or whatever it happens to be, if they say you can now, your license, you have your license back, I don't think we want the agency to say, yeah, but you still can't do X, Y, and Z.
So,
is that right?
Mr. Chair?
Yeah, no, Mullen.
So I appreciate what the agencies are saying, and I'm very happy with that. That sounds like an awesome process that they're going to go through, and the workforce development aspects of it, I understand. I think the point that Mr. Gonzalez, and if he's still in the room somewhere in Zoom land, that would be awesome, is really more a code drafting question and less about the workforce question. And Ms. Allen has been very kindly raising her hand, and maybe she has been so good on drafting things. Maybe she can come to the rescue here as
Rebecca
well.
Allen. Rebecca, go ahead.
Yes, thank you, Mr. Chair. To the point that is under discussion right now, it is correct that the draft doesn't, it allows each agency to set up its rehabilitative factors. And if the joint subcommittee wanted to consider giving some discretion to the agencies, you need to come up with factors, but the factors have to include at least X, Y, and Z. That might be something, Delegate Mullen, that could provide some reassurance to you. For example, if a person who's asking for a waiver has had whatever their professional license permit registration is restored by their regulator, that would be a factor that would have to be considered. And also building on the point that happened probably about 30-40 minutes ago about whether a waiver granted by DSS should be an automatic waiver granted by VDH. I think there's just different risk assessments that go into the different programs that are being regulated. So whether VDH would be willing to grant someone a waiver who's to a person who's going into folks' home versus someone who's working in adult daycare. I'm not sure about that transferability thing, but that could be a factor that would be considered, that if you've gotten a waiver from another agency, that should be a factor that weighs positively in the analysis that this agency would be evaluating. So it's kind of sort of a split the baby sort of situation of explicitly setting out some factors, but leaving some factors to the agency to set based on the individual risk assessments for the programs that they're regulating.
Sure.
Yeah. Senator Serval.
Thanks. I agree 100% with what Ms. Allen said for a couple reasons. I think what she's saying is that we ought to put some minimum standards in code, which I agree on, and then they could supplement with additional factors, which I would hope or anticipate they would put in writing. And Anna and Sabrina, I think they ought to have to put whatever their criteria is in writing for a couple reasons. Number one, I think we ought to have this minimum standard in code or whatever, because you know what? I lived through the 90s, and we could have a different governor who could have a different point of view about all this, and they could decide that we're being way too permissive handing out these waivers, and that some new governor comes in and wants to scope it way back. You know, I saw it happen in the 3 administrations I've served in the legislature, and so I think, you know, we ought to put something in code that at least locks in some minimum standards. Number one. Number two, it's important because if we're going to have an appellate process, I think there needs to be standards by which the appellate body, the circuit court judge, can go back and review the decision against some standard criteria. Otherwise, the circuit court judge isn't going to know, you know, how to evaluate the appeal, and all they're going to do is, these guys are experts. They had a factual basis for doing what they did. Affirm, right? So there needs to be some written standards somewhere, so that when the thing is appealed, somebody can go back and look and say, okay, the law was followed, the standards was followed, there was a factual basis for this consistent with the standards which they were supposed to judge against, et cetera. So it seems to me that all that needs to be incorporated into this. I think that's all good idea.
In writing.
Yeah, that too. Yeah, if there's a denial, the denial ought to state the basis for the denial in writing too. I agree with that, Delegate Mullen. Anna and Sabrina.
Okay, any other questions or comments? Yeah,
Mr. Chair.
Delegate Price.
Yeah, I just wanted to reiterate something that you said, and first thank all of those that were giving public comment, even those that said that they were nervous. It is so invaluable to have folks with lived experience to comment. And I think we share values based off what I'm hearing you want the commission to move forward with, but I really do invite those that would potentially be going through the waiver process to rewatch this and then give us written public comment on some of the pieces that we were talking about, because I would hate to create something that is too onerous to navigate, especially since the whole point of this is to get people into the workforce and to do the things that they would be really good at and effective at to help others. So just really encourage people to get back in touch with us.
Yeah, I agree. Anybody else have any comment? Let me ask you a question. Have any of the agencies we've asked to look into this, think we don't need all the crimes that are there. Get rid of some of these crimes. Anna?
Mr. Chair, we have posed that question. I think although they have provided some information in their presentations regarding crimes that they see a lot, I think that the position of all the agencies have been they cannot recommend crimes to eliminate, as that would be a policy position that none of them are prepared to make at this point. And if you correct me from an agency, feel free.
One of the things we talked about last time, as I recall, we have the federal standards we're stuck with. Why do we need the others? I'm not saying we don't, but what other categories besides what the feds are doing do we really need to put in the code?
Mr. Chair, that only applied for the child welfare and child care services. We don't have minimum federal standards for all the other areas. And we did implement the federal standards to apply to foster and adoptive parents. But beyond that, the other agencies, I don't think had minimum federal standards. So that's why we kind of have to create our own.
So what we have here is the agencies aren't willing to say anything, right? No comments from the agencies because they think it's a policy decision that they don't think they have the ability to make. Is that it? Is that it?
I don't want to speak on behalf of the agencies. They've certainly been very helpful in developing this draft. But I think as far as recommending specific crimes, I do think they do view that as a policy decision.
We specifically asked them to help us out, and they were not doing it. So I guess we'll have to make the hard decisions. And go through
Mr. Chair.
Yeah, Delegate Price.
You do have a hand up with the Virginia Department of Social Services.
I'm not seeing it. Who's that? Nikki?
Yes.
Okay, Nikki, go ahead. I'm sorry, I didn't see.
Mr. Chair, thank you. I just wanted to, in answer to your question, the Department of Social Services Division of Family Services oversees the barrier crimes for foster and adoptive parents. And we are recommending, and it is in the draft, that the crimes, the barrier crimes be changed from our state code, which would be under that 19.2-392 code section that we've been referencing, and switch it to the federal standards, which are we must abide by those regardless. And so we would, even in a waiver process, would not be able to provide waivers for any of the federal barrier crimes, but we would recommend, and that is in the draft that has been provided to you, that we would be asking that those standards and those crimes be changed to the federal.
Okay, so you are doing it. Yeah, that's what I asked for, that you're saying only the federal standards, the federal crimes would be applicable. And of course, if there's no waiver there, is that right?
Correct. Yes. And it would, if that were to go into effect, it would essentially nullify a waiver process for that particular. I'm not speaking on behalf of the barrier crimes under licensing, but this would be just for foster and adoptive parents under family services.
Okay. Thank you. I appreciate that. That's exactly what we asked for. Yeah. Thank you. Okay. Any other questions or comments? Okay. Where do we stand right now?
So, Mr. Chair, we have a lot of, somebody else just say something.
Sorry, go ahead.
Sorry, go ahead.
Yeah,
Mr. Chairman,
okay.
I sent a list to Anna, Sabrina, of things that I thought we talked about them correcting, and I copied you on it, Mr. Chairman, although I just added another one verbally to it about 5 minutes ago. But
Sure, I have it all.
if you go look at that email, I think that's what needs to be done.
Mr. Chair.
Yeah, Delegate Price.
Yeah, I would add to that potential creation of, and it may just be said in a different way, potential creation or at least looking into a navigation system to help folks walk through this. But I do, I wouldn't call it disappointment because I think everybody is doing what their jobs allow, but I feel very it's an interesting position to try and make decisions based off what crime should or should not be on the list without input from the people that would be hiring within these agencies. And so if it's not the folks that are on the call, no hard feelings, who are those people? Who can we speak to about the best practices within their agencies, about what can or should and shouldn't be done, so that we're hearing from real life information and data in order to make these decisions? I am very much open to removing some of these crimes in order to get at the workforce issue, in order to get at the second chances, all of the values that we've heard. But in order to make a policy decision, I feel like I need more information. And so I did not know if someone could at least suggest where we might be able to go for more information outside of DSS.
I agree. Anybody have a response to that? Yeah, Rebecca Allen.
Thank you, Mr. Chair. So VDH's issue is right now, the way that our laws are written, we don't have a hand in the barrier, like the conducting of the barrier crimes background checks. We only know whether or not a agency has hired someone who has a barrier crime was when we go on site for inspection and do randomized pools of employee records, and we check to see if that background check is there, and if it is, does it contain any barrier crime? So we don't have any data of who's being denied, who doesn't even get employed at all. The only issue we're running across is when employment offers have been made and accepted for someone who has a barrier crime, and we catch it when we go out when we do inspections. So in terms of who's the best folks to talk to, it would actually be the industries themselves, and I'd be more than happy to provide contact information to Anna and Sabrina and Sean after the meeting of the relevant industry groups that VDH regulates, so that their members can, they would be in a much better position to tell you who they are denying employment to because of what's coming back on a barrier crime check than VDH would be, because that's not even something we would see when we go and do our inspections because of how our statutes are currently set up.
Okay, can you give that information? That'd be good. All right, thanks. Anybody else have any comments? Yeah, the whole idea of bringing in the agencies for them to take a look, and except for DSS, it sounds like they don't want to do it. Yeah, Stacy?
Chairman Edwards, we did provide to Anna and Sabrina lists of the crimes that we are finding to be the biggest barriers for them to look at that. We provided the list of crimes that we really never see that are on the barrier crime list. So we have provided input to which crimes, maybe not at the level that you're discussing today, but we have provided input, and we certainly can go back and look at that.
Yeah, could you please do that? I mean, you're all in the best position to know where the issues are, the problems are. Okay, thank you. Anybody else have any comments? Okay. Okay, what's next on the agenda here? Is Senator Sherwood, do you have something else? No? Okay.
Mr. Chair,
Yeah, Delegate Mullen.
how many more meetings can we have?
I don't know. Hey, Sean, how many do we get?
Mr. Chair, we have one more meeting remaining this interim, and that meeting has to occur before November 30th.
Okay, so when are we going
Mr. Chair,
have another date? Yeah, Senator Sherwood.
I believe also that if our joint committee is going to issue a recommendation, then we need to actually have a meeting in person and have a sufficient quorum to take a vote. So we need to be careful about setting the date.
All right. Okay.
Mr. Chair, Senator Serval, that's exactly right. We'll have to have a quorum of members assembled in person in order to take any votes or make any official recommendations.
Okay. All right. Keep your calendar clear. We may be back in Richmond for some other reason too. In November. Maybe the next week. I don't know.
Mr. Chair.
Mr. Brinio can fill us in on that, I think.
Not legally. Mr. Chair.
Yeah, Delegate Price.
I know that we're going to get a poll, for our availability. I do just want to make sure that we give ourselves time. If we're getting the contact information from Ms. Allen on the industry folks that the VDH regulates, I would love to see the list of biggest barriers to hiring and the crimes that they never see from DBH DS. But then also looking into some of the things on Senator Saravel's list. I think the fiscal impact is probably what a lot of us are a little bit worried about before we vote on some things. So I would love for us to get a sense of how much time we need in order to get that information back, and then poll based on dates after that as possible, so that we don't show up in person but not have all the information that we need to make the best informed decision.
Yeah, I agree.
Mr. Chair.
Thanks. Yeah, Rebecca Allen.
Thank you, Mr. Chair. On the subject of the potential fiscal impact, did the joint subcommittee come to a consensus on how the waivers, if granted, were going to be communicated to the public? Because I believe the first draft that I got from Anna and Sabrina had it being somehow communicated back to the Department of State Police to be included on the records check. But then the draft that came out for the meeting, that was taken out, and it's now in the employment or volunteer record. Because the answer to that question will impact the fiscal, or will change the fiscal impact for us.
Sure.
Ms. Rebecca, we deleted that out. The first draft, we purposely deleted that out, and we do not plan to have that in this draft, as far as I know, probably. All the senators.
Okay. Anybody else?
Mr. Chairman.
Yeah, Senator Sherrill.
Yeah, so I learned some very painful lessons as part of the automatic sealing, petition-based sealing legislation about fiscal impacts. When you start monkeying around with public, or I should say with Virginia State Police criminal histories. And one of the reasons that we have a 4-year delayed enactment on that is because they're going to have to do a $15 to $20 million rebuild of their entire computer architecture. And that's going to take some time. And part of some of the things we discussed today relate to that. And to the extent we could piggyback on what they're doing, the fiscal impact, I think, would be a lot less. And so we need to, as part of this, get a sense of what our options are, understand what they cost, figure out where we can try and get some efficiency by piggybacking on some things that are going on, and then make our decisions accordingly. And which I think is kind of what Delegate Price was hinting at in terms of gathering information so that we can make some informed decisions when we make them, so that we don't make a decision that ends up having a $20 million fiscal impact or something and blows the whole thing up when we get to regular session. So I think that, Mr. Chairman, is a big part of this. So I would just note that.
And Mr. Chair,
yeah.
Mr. Chair, I just make a request of scheduling staff that as the doodle poll gets sent out, that we also include some afternoon dates as well, since my court schedule is much heavier in the morning and I can make afternoon dates a lot easier.
Okay, let them all come in and plead guilty. That takes care of the problem, right?
Not with jury sentencing anymore.
Yeah, well, that's true. All right. Any other comments? Early on, we talked about the assault and battery issue. We had 3 categories, I recall. I don't think we ever resolved that, did we? Anna? The assault and battery issue?
No, Mr. Chair, I don't believe so.
Sabrina. Okay.
No, that's okay.
How are we going to, all right, you want to explain that again, the 3 categories? Are we supposed to make a decision on that now?
Mr. Chair, any input would be helpful. The options, let me go back to my sheet here.
Bring it up on the screen. Do you want me to, Sabrina?
Oh, sure. That would be helpful.
You all can send us stuff after the meeting as well, too.
Yeah, absolutely. So just the one consideration was that I know that, as I had said, based on the list that was provided to us from DBHDS of the kind of the crimes that made up the most barriers, assault and battery was the top. And so that was one of the couple options that I just wanted to present to the subcommittee is that we can have either of these options. So either making it felony only, which is option 1 on the screen right here, or option 2, just taking out more than one conviction of simple assault. So that would essentially be 2 if there is a third or subsequent that would constitute a felony if it's charged that way. So just additional considerations.
And there's assault and battery, and there's assault and battery. Felony assault and battery is a very different animal than just misdemeanor assault and battery.
Correct.
Mr. Chair?
Yeah, Doug Mullen.
Just in terms of so I don't know what a felony third or subsequent of assault and battery. What?
Domestic is that way.
Yeah, I mean,
Regular
there's domestic, but just regular assault and battery isn't.
Right.
So, I'm fine with that. I guess that's the only one that I can think of.
Standard misdemeanor assault and battery. I don't think got to be included. No.
Yeah, I think
one thing.
Yeah. So, yeah, I'm fine with that.
Okay, let's go with option 1.
Yes, Mr. Chair, that's perfect. We'll draft that in there.
We'll do with option 1. I think we'll agree with that. No other options. Because there's so much, I mean, I see it all the time. I'm sure, Doug Mullen, you sit in the courtroom all the time too, right? Routine, just simple assault. Assault and battery. Okay. All right. We got that resolved. Anything else? So we need to get a date, right?
And they know they got the code section wrong, right? Like
the code section?
Mr. Chair, and Delegate Mullen, yes, I see that I think I was flipping back and forth between the two. I understand.
But that's fine. Okay.
Okay. All right. Any other business come before the body? Well, keep your powder dry and your days clear to get together in Richmond. At least get a majority or how much do we have to get a quorum? What, a majority? Is that a quorum?
Mr. Chair, that is correct. And with your permission, I'd like to reach out to you directly to understand whether our ex officio members will also count towards a quorum.
Yeah, I don't think they do, but maybe they do. I don't know.
Understood, Mr. Chair. Thank you.
Okay. All right. Thank you all very much. If no further business, we'll go ahead and adjourn the meeting. Thank you very much. It's now 4 o'clock, 2 hours.